Malik Spearman, file number 2023-21348FH. I have Rhonda Underwood appearing on behalf of Mr. Spearman, and I have Isaac Sneed appearing on behalf of the people. We were last here for arraignment, and this is the date time set for a pretrial in this matter. Ms. Underwood, how would you like to proceed on behalf of Mr. Spearman?
Your Honor, we will be asking for a COBS in this matter to the low end of the guidelines, no more than 12 months.
So say that again, Ms. Underwood.
We will be asking for a COBS in this matter to the low end of the guidelines.
All right.
And no more than 12 months.
Mr. Sneed, do the people have any position?
Ms. Underwood hasn't shared any guideline scoring with me, so I really can't weigh in on that.
Okay. Ms. Underwood, I understand the low end of the guidelines, but I can't agree to no less than 12 or no more than 12 months because I don't know what the guidelines are.
Mr. Spearman, do you understand that the judge will agree to the low end of the guidelines, whatever that is?
Yeah, I understand that she agreed to the low end of the guideline, but if it's more than 12 months, I might as well take it to trial.
Okay, well, I can't, Ms. Underwood, because I don't know what the guidelines are. I haven't had a conversation.
And I understand that, Your Honor.
All right, so would this be
if you could give me a few minutes, maybe, or
okay.
if the court would like to bring Mr. Spearman back.
No, I'll give you a breakout room. So hold on.
We don't need a breakout room for this. We already talked about it. I mean, if I can.
So Mr. Spearman, hold on. So there could be a COBS to whatever the low end of the guidelines are, but I don't know what they are. I don't know you. I don't know your record. So I can't agree to 12 months. But your guidelines could be less than 12 months. They could be more than 12 months. I don't know. Whatever Ms. Underwood calculated them at, she's probably correct. She does a good job on those, but you know, it's up to you. Do you want to enter a plea or you want to set up?
Yeah, if it's more, so nobody here know what the guidelines are?
Mr. Spearman.
So Mr. Spearman, I understand, I used to work in Wayne County and we did the guidelines and they were available at the time of a plea. We don't do that here in Lenawee County. So I understand in some jurisdictions, you may know exactly what your sentence is going to be at the time of entering a plea, which is very helpful. But in this county, no, we don't know what the guidelines are.
Yeah, I'm not going to just cop to something.
Okay,
I'm not
so
cop to something that can be
Mr.
2 or 3 years.
Mr. Spearman.
All right, Mr. Spearman, that's fine. I'm going to set this for, let's see, we can do, I can either set it for a trial, Ms. Underwood. Looks like it would be a 1-day trial, or I can set it for another pretrial, Ms. Underwood.
I think another pretrial, Your Honor.
All right, so Mr. Spearman, I'm going to set this for another pretrial on July 26th at 8:30 in the morning. And that'll give everybody a chance to review the guidelines and that Ms. Underwood's prepared and maybe give you a more definitive answer. So we'll see you back on July 26th at 8:30 in the morning. Ms. Underwood, can you prepare the stiffen order to adjourn?
I will do that, Your Honor.
All right, very good. So thank you, Mr. Spearman.
I just would like for everybody to be on the same page here, that's all.
Nope, absolutely fine. All right, you're all set, Mr. Spearman. Thank you.
Thank you.
That's July 26th, Your Honor.
Yep, at 8:30 in the morning.
Getting them places
All right,
still
Ms.
done?
Hennigan,
Oh, no. What are you gonna do?
Mr. Pagan, can you hear me? All
Yeah, I can hear you, ma'am.
right, Ms. Underwood, do you need a breakout room with Mr. Pagan?
Yes, Your Honor.
All right, Mr. Pagan, I am going to open up a breakout room with you and Ms. Underwood. Go ahead and join that room. Ms. Hennigan, are you ready on Mr. Tedder's or Ms. Moser? I'm sorry.
Yes, good morning, Your Honor.
All right, this is in the matter of the people of the state of Michigan versus Kenneth Charles Tedders, file number 23-21265FH. I have Madison Moser. What's your P number?
86518.
All right, appearing on behalf of Mr. Tedders, and who's my prosecutor? Isaac Sneed
No,
appearing
Your
on
Honor,
behalf
that's
of.
mine. Sarah.
Oh, I'm
Brennan.
sorry. He had his picture in. Sarah Brenner appearing on behalf of the Attorney General's office. So, Ms. Moser, how would you like to proceed today?
Your Honor, I had a chance to speak with Ms. Brenner, and we both agreed that it'd probably be best to adjourn this out 60 days now that Mr. Tedders has established employment in Ohio. He reported his info to the front of the court and made $100 payment at that time, and he's received an income withholding order in the mail, so payments should be coming out of his check shortly. We just asked that this be adjourned out 60 days so that Mr. Tedders can make payments.
And Your Honor, we're looking at a potential delay plea deal, but I just need to see consistent payments from him. Apparently, he didn't understand that it doesn't just magically come out of your paychecks. You have to actually inform the front of the court. And if it doesn't magically come out of your paychecks, then you actually have to be a big boy and pay it on your own. And so I need him to understand that if it's not coming out of his checks, he needs to pay it anyway. And so sometimes that does take some time to get in place. So it's his responsibility to make sure that that is taken care of each month and that his kids are. Now, he does have multiple child support orders still. So he needs to at least make sure that this one is maintained if we're going to look at doing that delay of sentence deal that I've spoken with his counsel about.
All right, so, thank you, Ms. Brenner. You know, you have a toddler, you can tell. So Mr. Tedders, she's correct. And a lot of people don't realize if it doesn't come out of your check, you have to personally make that payment. So make sure that until it starts coming out of your check, you divide whatever that amount is and you make that payment every week until it comes out of your check, okay?
Okay.
All right, so we'll see you back on August 9th at 8:30 in the morning. And Ms. Moser, if you can prepare the stipend order to adjourn. Ms. Brenner, can she sign your name with permission?
Yes, thank you.
All right, so thank you, Ms. Brenner, Ms. Moser, and good luck, Mr. Tedders.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, so let's see.
I'm ready on Spalding with Rhonda too, since she's back, Judge, if you have that one ready.
I don't have Spalding. I don't
Oh,
know.
okay.
You should have him.
Well, I got lots of people that have their name on, so hold on. I got Mr. Mawad. I got Mr. Sala. I got Mr. Malaro. You have. Hold on. All right, I'm gonna send connection information, whoever the gentleman is there. And, oh, this guy here. Is there anybody in the courtroom that's a defendant today? No, we're just hanging out. All right, Ms. Adams from the jail, could I get Jeremy Sneed?
Okay.
All right, I have a gentleman in a buffalo plaid shirt. What's your name, please?
Joseph Johnson.
All right, so I'm gonna rename you. Who's your attorney?
Mr. Murphy.
All right,
Your Honor, could I have a breakout session, Mr. Johnson?
okay. Let's see. I'm going to put Mr. Johnson and Mr. Murphy into a breakout room. You should have gotten an invitation. Go ahead and join that. I'm gonna bring Mr. Pagan back. His breakout room. Now I have another, wait, where'd he go? I don't know. He's back. Awad. We have Sala has Mr. Perez Martinez. Is he with you, Mr. Sala?
He is on the screen. It's for Pedro Hernandez with the black shirt. 100118886, it says on the screen.
I have you down for, oh, that's at 1:30 today. I'm sorry. So the black shirt is Pedro Hernandez.
Yes.
Are you okay? So you.
I really have seven vacancies and one.
Okay, so Mr. Mawad, Mr. Sala did zoom in before you, so let me take him and then I'll bob around. All right, this is in the matter of the people of the state of Michigan versus Pedro Hernandez, file number 23-21325, Mr. Hernandez, and I have Christopher Fleming appearing on behalf of the people. This is the date and time set for a pretrial in this matter. All right, Mr. Sala, how would you like to proceed today?
I guess we'll set it for trial at this point. Mr. Fleming and I have had some conversation, not a lot. Maybe we can work something out, but in the meantime, maybe set it for trial.
All right, how many days do you think a trial would be?
One.
1 day trial. Okay, so I have, he's not in custody. So I could set this for, it's a newer file, it's a newer file. So I could set this for September 20, or about October 17.
October 17th would work for me.
That works for me.
That'll be at 9 a.m. Thank you. And then I will set a final pretrial for October 4. And that will also be the day for all motion deadlines, as well as jury instructions and voir dire questions being provided to the court and exchanged. Mr. Sala, have you received all discovery you needed?
I believe so, Your Honor.
Right, was a preliminary exam conducted in this case?
No.
All right, so I filled out a scheduling order and we will send that out to everyone. And Mr. Hernandez, I will see you back for pretrial on October 4 of 23. If Mr. Sala and Mr. Fleming, if you want to avoid zooming in for hours on a Wednesday morning, if you guys reach an agreement for a plea, please let me know and I will bring you in at your convenience on a day not Wednesday.
Thank you, Your Honor.
Thank you.
All right, Mr. Hernandez, you're all set. We'll get a copy of the scheduling order out to you. Thank you.
Thanks, Your Honor.
Thank you. All right, thank you, Mr. Sellers. See you at 1:30. All right. Mr. Pagan, Ms. Underwood, no.
Ms. Judge,
Yes, Mr. Pagan.
I haven't received no paperwork since I've been incarcerated in Gus Harrison facility for my lawyer. Nothing. I haven't received nothing.
Okay.
And I'm asking her to send me something, or maybe it's
Well,
best to get a
Mr.
different lawyer.
Pagan, Mr. Pagan, I don't have your attorney available right now. so I don't want to talk about the case until she comes back online. There she is. All right. This
I'm
is a
sorry, I
matter
apologize, Your
of
Honor.
People of the state of Michigan versus Ricky Lee Pagan, file number 22-21142FH. This is a date and time set for a pretrial in this matter. I have a letter from the Department of Health and Human Services stating that they received a request for criminal responsibility and competency, and that it is in progress. Have you received the report yet, Ms. Underwood, or?
We've received the report as to competency, Your Honor. We have not received the report as to criminal responsibility. So I was going to ask the court to put this over for another pretrial.
Okay, and Ms. Underwood, I think the client's asking for a copy of the police report and felony information.
Your Honor, we have sent that, but we will send it again. And I also told Mr. Pagan that I will be visiting him at the facility since it's a problem doing telephone.
All right, so Mr. Pagan, they're gonna send you your information again, and then she will be over to visit you. How about an August pretrial, Ms. Underwood?
That sounds appropriate, Your Honor.
All right, so Mr. Pagan, I'm gonna set this over to August 30 at 8:30 in the morning for another pretrial. Ms. Underwood, you do the step order to adjourn?
Yes, that date again, Your Honor.
August 30 at 8:30 in the morning.
Thank you.
All right, Mr. Pagan, she'll send you all your paperwork and we'll see you back on August 30, okay?
All right, thank you, Judge.
Thank you, Mr. Pagan. You have a good day.
Have a good day.
You too.
Yeah, I got it.
All right, let's get out of here.
Okay, so Mr. Muwad, who do you have today?
Judge, I've got Kelsey Quinn. Ms. Arnold and I were just going to pick another date. I'm not sure if she's in the audience. I don't think she's on Zoom. Is she on Zoom? Kelsey Quinn?
No, I do not see her, but I'm fine if you just want another pretrial. So let me grab
Yeah,
her
if we can
file.
wait, if I can waive her presence, I'll call her to find out what happened. She's been a great client. She's always attended every hearing, so.
Awesome. All right, this is in the matter of the people of the state of Michigan versus Kelsey Leanne Quinn, file number 22-21168FH. And Elias Muwad appearing on behalf of Ms. Quinn, and Allison Arnold appearing on behalf of the people. She is, let's see, so this is a date and time set for a pretrial. Let me find you here. And how far out would you like another pretrial?
Allison, go ahead. Allison.
I don't know if July 5th works for Mr. Muwad. That's the date that the co-defendant Moda is set for pretrial. Sam Bennett and I are trying to work out a plea in that case, and that the resolution of that case will resolve this case, I believe. So it might be appropriate to set it for that date. I think if Sam Bennett and I reach a plea agreement, we'll try to put it on the record before that date, though.
I always appreciate that. Are you available July 5, Mr. Muwad?
I know that's a rough week, so I'm not, if we can't.
No, that's okay. This case has been pending for all of us. I think the quicker that we have answers, the better. That's fine, Judge. That's fine.
Okay, so I'll set this for July 5 at 8:30 in the morning, and you guys will do a step in order to adjourn.
Yep. Allison, I'll sign your name if that's okay.
Yeah, and if we reach a deal, Judge, we'll try to put this on before the 5th too.
Yep.
All right, I appreciate that. Thank you.
Thank you, everybody.
All right, from the jail, do I have Jeremy Steen? Tell them you're muted. Do you have a mouse to unmute that?
Yeah,
There you go. You're Jeremy Steen.
yeah.
All right, this is in the matter of the people of the state of Michigan versus Jeremy Allen Steen. We have two files, 23-21384FH, and then we have 21-20208FH. The 21 file is a violation of probation pretrial, and then the new file is obviously set for pretrial. So, Mr. Glazier, Mr. Malaro, Sam Malaro, I'm sorry. I have Salvatore Malaro appearing on behalf of Mr. Sneed, and I have, who's my prosecutor? Oh, Phoebe Meir appearing on behalf of people. So, Mr. Malaro, how would you like to proceed today?
Your Honor, before we proceed to arraignments, should I talk to my client in a breakout real quick?
All right, so. Close on these breakdowns. So, Mr. Sneed and Mr. Malaro, you should get an invitation to join a breakout room.
Okay.
Thank you, Judge.
Mr. Glazier, do you have any clients that aren't in jail?
Your Honor, I'm waiting for Mr. Allison, and then I wanted to do him by Zoom, and then I'm gonna come over in person on Diethos.
Is Mr. Diethos?
Yes, you, sir.
All right, Mr. Diethos is here.
Yeah,
So
I thought I would do Allison first, since he's in jail. I can do him by Zoom, and then I'll come over there in person for Diethos.
okay. So the jail room is busy right now because of Mr. Sneed is in there, but do you have anything in front of Judge Olsaver?
Nope, I'm just here. Finish this
Just
one
me.
and then I'll be over.
All right, so Miss Adams, could you let the jail know that after Mr. Sneed, we will need Mr. Allison?
Okay.
Okay. What are you hearing, Mr. Hurton?
Allison.
Oh, okay, so Mr. Johnson, are you?
Yes.
Oh, there you are. I'm going to
Yes, sorry.
file. Nobody in here is a defendant, right? We're all just here to watch. All right, this is in the matter of the people of the state of Michigan versus Joseph Anthony Johnson. We have two files, 23-21344 FH and 22-21089 FH. I have Matthew Murphy appearing on behalf of the people, or no, Matthew Murphy appearing on behalf of the defendant, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for pretrials. Mr. Murphy, how would you like to proceed?
Your Honor, I spoke with Mr. Sneed about this case yesterday. The prosecutor's still trying to figure out an offer encompassing all of Mr. Johnson's cases, which is something I wanted to bring up as well, is that there's another case. I believe I have it set for the 21st. The case number 2321344-FH. And obviously, I was going to ask to set all these for another pretrial. Again, that one was scheduled, I think it's scheduled for the 21st. I didn't see the reason to come back on the 21st for that one. If we could adjourn that as well today. I don't know if.
So how far out would you like an adjournment on these three files?
Just about 30 days, I think, is all that's necessary to see where we're at. And then if we're going to set a trial at that point.
All right, so my next available is July 26th. So we could move all three files to that day, so you can do the stipend order on all three.
Yes, Your Honor.
All right, any objection to that, Mr. Sneed?
No objection, Your Honor. Thank you.
So, Mr. Jensen, we're going to adjourn your hearings to July 26th at 8:30 in the morning. You've been given notice on the record. Your attorney will do a stipend order to adjourn, and we will see you back on that day. All right?
Okay, thank you, Your Honor.
Thank you, Your Honor.
Thank you. Mr. Noe, I have your client.
If we could, Judge, just wait briefly. Co-counsel Mr. Amadeo should be with us shortly.
All right, Mr. Gotra, I'm gonna put you back in the waiting room. We're not quite ready for you. All right, Mr. Murphy, Mr. Jensen's done. Mr. Bernstein. Mr. Bernstein, Mr. Thomas has been here. He was here before even 8 o'clock. All right, Let's get Mr. Tom's connected. Mr. Murphy, it looks like I have Mr. Lau too.
I need to speak with him in a breakout, please.
All right, let me bring Mr. Lau in. All right, this is in the matter of the people of the state of Michigan versus Douglas Henry Toms, file number 2023-21221 FC. I have, who's my prosecutor? All right, I have Sam Bernstein appearing on behalf of Mr. Toms and Phoebe Meir appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So, Mr. Bernstein, how would you like to proceed today?
Good morning, Your Honor. I'm hoping for an adjourned pretrial date to continue speaking with Ms. Meir about the case.
How far out, please?
I've heard Your Honor give the date of July 26th out a couple times. Could I please hop on that date as well?
You can. So I'll set a pretrial for July 26th. At 8:30, any objection to that, Ms. Meir?
No, that works for me.
All right, and Mr. Bernstein, can you prepare the stip in order to adjourn then?
Yes, Ms. Meir, if I have your permission to sign that, I will get that to the court.
You do.
All right, thank you.
Thank you, Your Honor.
Thank you. Mr. Lau, can you hear me?
Yes, sir.
All right, I am going to, hold on, I'm gonna send you an invitation in a moment to join a breakout room with your attorney. So
Okay.
let me just do that.
Alrighty. Thank you.
You're welcome. Hold on, let me get Mr. Murphy back. All right. Mr. Murphy, there you go. Mr. Murphy, I'm gonna reopen that room so your client gets the invitation to join. There you go. All right, Mr. Malaro, Mr. Amadeo, I'll be right with you. Mr. Malaro, we are back on the record in the matter of the people of the state of Michigan versus Jeremy Allen Sneed. How would you like to proceed on these files?
Your Honor, we would proceed to arraignment. We would acknowledge receipt of the information as to count 1 and habitual offender notice. We'd also acknowledge receipt of a witness list. My client would stand mute at this time, ask for a pretrial date, hopefully within the next 30 days. And we'd also ask for a pretrial on the violation of probation to coincide with it.
Okay. 30 days, you said?
Yes, Your Honor.
Can I do August 2nd? Can I bump it another week? Because I just kind of filled.
August 2nd is fine, Judge.
Okay. All right, so Mr. Sneed, I'm going to adjourn both of these to August 2nd at 8:30 in the morning. Court will enter a plea of not guilty on your behalf on file number 23-21384 FH. Continue the not guilty plea on file number 21-20208 FH. And we'll see you back on both of those on August 2nd. All right, Mr. Sneed?
Yes, ma'am. Have a good day.
You too. Thank you.
Thank you, Your
Did
Honor.
we arraign him on the new charges, Judge?
Yeah, we did.
Okay,
You waived the reading and entered a plea of not guilty.
perfect. I did not hear that part. Thank you, Judge.
That's okay. All right, so. The only defendant I have available right now, and Miss Adams, if they can get Mr. Allison. All right, I'm gonna bring in Mr. Gotra. I have Mr. Noe and I have Mr. Amadeo. All right, this is in the matter of the people of the state of Michigan versus Surwinder Gotra, file number 22-21158 FH. I have William Amadeo appearing on behalf of the defendant. I have Charles Noe appearing on behalf of the defendant. And I have Phoebe Meir appearing, no.
She stepped away.
Christopher Fleming appearing on behalf of the people. This is the date and time scheduled for a motion. Court has received a copy of a motion to travel. Mr. Amadeo prepared that motion. So Mr. Amadeo, do you wish to proceed on your motion?
Yes, Your Honor. There's actually two matters for housekeeping today. There is the matter to travel, and there's also a plea. We resolve this case for your approval. I don't know if we want to take the plea first.
Probably.
Okay.
You know what?
All right.
Miss Mears
The
indicated
plea.
that she needs to be here for the plea, Your Honor. If we could just pass this for a moment. She'll be.
Is she in Judge Savers?
No, I think she just stepped away for a second.
Okay, so just be a second, Mr. Amadeo, Mr. Noe, and Mr. Gotra.
No problem,
So we'll wait to Miss. What case are you waiting?
Just watching.
Just watching.
Yep.
And I don't have anybody I have no defendants. The only person I have is Mr. Gotra. I'm not in my waiting room. I guess I can issue bench warrants for people who didn't show up. He's in jail.
Is Mr. Spalding in your weight room, Your Honor? He said he was.
No.
I'll call him again because he said he was there.
All right, Mr. Malaro. Oh, he's in jail too.
Yes, Judge.
Never mind, Mr. Reed is in jail, so we mark him
Never
in
mind.
jail. Was gonna issue a bench warrant.
Nope, don't do that, please.
Okay. That's it. Everybody I have is in jail. All right, I'm gonna step off the bench for 2 seconds. Take Becky.
Go back. Go back. Number one. All the way down.
So one more All right, this is, are you Mr. Allison?
I am.
Okay. This is in the matter of the people of the state of Michigan versus Michael Lee Allison, file number 22-20996 FC of John Leisure appearing on behalf of Mr. Allison and Douglas Hartung appearing on behalf of the people. I don't know whose P number is older. That's how I usually call it, but this is the date time scheduled for a pretrial. I do not have an updated stipend order to adjourn the pretrial from April 19th to today. It might be across the hall. If it wasn't done, I would just ask Mr. Leisure that you do that. So this is a date and time set for pretrial. How would you like to proceed today?
Well, first things first, Your Honor, what was the step that I was supposed to prepare?
To adjourn from the last date to today.
And that was April 19th?
I think, well, I think so.
Okay. All right, Your Honor, in this matter today, I'm excuse me. Excuse me. I've looked at the file and I do not have a criminal responsibility. I got the competency and I got a letter saying that the criminal responsibility would follow a month later, which would be June 18th. But so I'm looking for it, I guess, within the next 4 days.
Okay.
What I'd ask to do is adjourn this out. I got a feeling I can get my independent guy going on this, even though I don't have the criminal responsibility yet. I can at least begin setting up appointment for him to get with my client. And so he's not as long as he won't take as long as the site or the state of Michigan did. I would say, if you give us 60 days, I hope to have it done within 60 days.
All right, August 30 at 8:30 in the morning. Are you available that day?
On what date?
August 30. 30-8.
Yep, yes, I'd be available.
All right, so I'll set this for another pretrial on August 30th at 8:30 in the morning. And then Mr. Glazier, can you do the stipend order adjourning from April 19th to June 14th to August 30th at 8:30 in the morning?
You know I will, Your Honor.
All right. All right.
Whether
Thank you,
it makes it to the court or not, I don't know, but I'll prepare it.
All right. All right. Thank you, Mr. Glazier. Thank you, Mr. Arnold. Thank you, Mr. Hartung. Mr. Hartung, my bailiff will let you back. Okay, so Mr. Gotra. Do I have Ms. Meir?
Yeah, sorry about that, Judge.
That's okay. All right. This is in the matter of the people of the state of Michigan versus Sir Winder Gotra, file number 22-21158FH. I now have Ms. Meir. So Ms. Meir, Mr. Amadeo, and Mr. Noe stated we have two things today. Mr. Gotra wishes to enter a plea, and then there's also the motion to travel. At this point, it seems sensible to take the plea first before we address the motion to travel.
That's fine, Judge.
All right. Who, Mr. Amadeo or Mr. Noe, what is the plea offer in this case?
The plea we have resolved is my client will plead no contest to one count of felonious assault, which is a 4-year felony. There's a sentence agreement via Killebrew of no upfront jail. The justification for the no contest plea is there's pending civil litigation.
Okay, so Ms. Meir, you'll be amending the information to add a count 2 felonious assault.
It should already be done, Judge.
When was that done? Let me see here.
It was done maybe 2 weeks ago, and I sent it to both councils and the court, but I can send another copy. Maybe not.
Did it get
Sorry?
I don't know. I was just asking, did it get filed with the clerk's office?
It did. But I'll email another copy now.
All right, so, and then.
And the only amendment to that plea agreement, Judge, is that the people would be requesting at sentencing I'm trying to think of what it's called, what Mr. Jones calls it, basically like the sexual assault or sex offender treatment while on probation.
All right,
And
so,
no objection.
okay, so he's gonna plead guilty to count 2 felonious assault. There's Killebrew to no upfront jail.
That's
And
no contest plea.
requirement-
Yeah, no contest, Your Honor.
Oh, no contest, sorry.
Right.
And then, no upfront jail, and then he's to enter and complete sex offender treatment as a term of probation.
Correct.
Correct, Judge.
Correct.
Okay. All right, so, Mr. Gotra, you want to raise your right hand for me, please?
Yes.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record, please?
The first name is Survinder, last name is Gotra.
All right, thank you. All right, you can put your hand down. So, Mr. Gotra, you have heard the statement of your attorneys and the prosecuting attorney. Is it your intention to plead guilty to count 2, assault with a dangerous weapon, felonious assault, which carries a maximum penalty of up to 4 years in prison and or $2,000 fine? So is it your intention to plead guilty to that offense?
Judge,
Or no contest?
Yeah.
No contest.
Is that correct? Yeah, it's no contest, please.
Okay, and then you understand, you will, there's a Killebrew agreement between the prosecutor and your attorneys to no upfront jail, but then you will also be required to enter and complete sex offender treatment. Do you understand that?
Yes, Your Honor.
All right, are you satisfied with both Mr. Amadeo and Mr. Noe as your attorneys?
Yes, Your Honor, I am.
All right, other than the Killebrew agreement, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Amadeo?
That is correct, Your Honor.
Mr. Noe?
Yes, Your Honor.
Ms. Meir?
That's correct.
And Mr. Gotra, as far as you're aware, is that correct?
Yes, Your Honor.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecutor prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yes, Your Honor.
All right. And, this case will not carry any penalties under the Michigan Sex Offender Registration Act, but you will be required to take sex offender treatment. Do you understand that?
Yes, Your Honor.
All right. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. How do you wish to plead to the charge that on or about December 3rd of 2021, in the city of Adrian in the county of Lenawee, that you did commit the offense of assault with a dangerous weapon?
What was that? Yeah. No contest, Your Honor.
Okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsels aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Amadeo?
No, Your Honor.
Mr. Noe?
No, Your Honor.
Ms. Meir?
None, Your Honor.
Mr. Gotra, other than the agreement that was placed on the record, has your attorney promised you any other particular sentence or estimated what your sentence will be in terms of length of probation, requirements of probation, or fines and costs?
No, Your Honor.
Okay. Is it your own choice to plead no contest?
Yes, Your Honor.
Right, and who will be placing the factual basis on the record?
Your Honor, with defense's permission, I would just ask for a stipulation as to the Michigan State Police report number 146072-21, specifically a supplemental report numbered 7, and that I would take some excerpts of the victim's statements out of that supplemental report to establish a factual basis.
Any objection,
Defense will not-
Mr.
No objection to that, Your Honor.
No, Your Honor.
Mr. Noe? Okay.
And-
May proceed, Ms.
Thank you. And for the record, that report was authored by Trooper Elise Kirsch. It's KIRSCH. And it was a supplement that was dated April 16th, 2023. However, the original report date was December 3rd, 2021 of the case. And within this supplemental report of victim, Judge, do you want me to use the victim's initials?
Initials always on a minor, yep.
She's not a minor.
Oh, in a sex offense, yeah.
Okay. So the victim with the initials CZ, she did report to the Michigan State Police that she was at Club Eclipse and did come into contact with this defendant, Mr. Gotra. And when coming into contact with Mr. Gotra, she was in a room alone with him at this club. She did not feel as if she was free to leave. She was becoming fearful of Mr. Gotra, and he did use his hands to put her on the ground and forcefully put his penis in her mouth. Again, that's a quote from that victim. And it was so forceful that it did cause an assault upon her. And at that time, she was again fearful of Mr. Gotra. And I think with that, Your Honor, it does establish that he did use his hands to complete this assault on this victim.
All right. Mr. Amadeo, any additions?
The only thing I would add, Your Honor, is, and this is for the sole purpose of the plea, this occurred on December 3rd of 2021 in the county of Lenawee. And for the purposes of the plea, I have no objection to what Ms. Meir presented.
And that was the city of Adrian. Sorry about that.
Yep. Mr. Noe, anything else?
Nothing, Your Honor.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about December 3rd of 2021 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of assault with a dangerous weapon or felonious assault by making assault upon CZ by using his hands to hold her down on the ground. And she was fearful of the assault and did not give permission, and that the assault involved I'm sorry, Ms. Meir, did you mention the sexual penetration or not? I think you did.
I did. I just said that he did use force with his hands to complete that.
Yeah. So he held her down on the ground and used force to insert his penis in her mouth without her permission. So therefore, I do find that the defendant did commit the offense of felonious assault or assault with intent or assault with a dangerous weapon, and the court does accept the plea. Has court complied with the MCR 6.302 B, C, and D? Mr. Amadeo?
Yes, you have, Your Honor.
Mr. Noe?
Yes, Your Honor.
And Ms. Meir?
Yes, Your Honor.
All right. Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Killebrew agreement that was placed on the record, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorneys, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the Michigan Department of Corrections for a pre-sentence investigation. I'm going to set sentencing on July 27 at 8:15 in the morning. Because there's a Killebrew agreement between the people and the council for no upfront jail, Mr. Noe and Mr. Amadeo, do you wish the sentencing to be via Zoom or in person?
Zoom, Your Honor, please.
I would agree.
Okay, so we'll set that via Zoom. Mr. Gotra, oh, I'm sorry, Ms. Meir.
I'm sorry for interrupting. I am going to be unavailable on the 27th. Could we do a different sentence date?
Yep, Ms. Adams, can I get another date, please?
Thank you.
Okay. August 3rd at 8:15.
That would be perfect.
Mr. Noe, Mr. Amadeo?
I have.
We'll make that work.
I have another sentencing in front of Judge Olsaver, on that same.
Well, we have about 20 between us, so we'll wait for you. Yeah, usually on sentencing day, there's like 10 here and 10 there, so we won't. All right, so August 3rd at 8:15 in the morning. And when I'm done here today, Mr. Gotra and Mr. Noe, I'll pop you in a waiting room with Mr. Moore so he can get some information and give instruction to Mr. Gotra. So we can move on. Mr. Gocher, when you meet with them, be truthful about your background. Obviously, you entered a no contest plea, so you don't have to make any statements regarding the offense. And then we'll send that to your attorneys. They'll review it with you in advance. We'll see you back on August 3rd. So.
And Judge, one question, for the stipulated to police report, just that supplement, should that be forwarded to either Mr. Moore or Mr. Jones? For the PSI? Mr. Jones? Okay.
Okay. Mr. Amadeo, you drafted the motion. Do you wish to make argument on the motion?
Yes, Your Honor, thank you. My client has 2 retained counsels. He just pled today with an agreement to no upfront jail. He has not been home in over 2 years. He wanted to visit his wife, who he recently married, who he met abroad. The people did not stipulate to such, but they didn't object to anything. And I think clearly that he's no danger of flight risk. We even have a Zoom sentencing. And also the fact that he has no prior felonies. He's never been before this court before on such. I would ask you to allow him travel to go see his family.
Ms. Meir?
Judge, I didn't file a response to this motion simply because I would just leave it in the discretion of the court. I think it's more a matter for Your Honor to decide than for me. I don't strongly object. I think Mr. Gocher has been fairly cooperative with both this investigation and the case, and he did have permission to travel outside of the state at one point, not obviously outside of the country, but outside of the state at one point, and he returned and did what he needed to do. And so with that, I'll just leave it in the discretion of the court and whatever the court deems necessary.
Well, we obviously have a very strict policy with the Michigan Department of Corrections that we don't allow travel outside of the United States. There is a 1997 treaty for extradition between India and the United States, but his wife is more than able to come visit him here if she would like. So I'm going to deny your request for a motion to travel.
Okay.
All right, very good. Thank you.
Thank you, Judge. Have a good day.
All right, so Mr. Noe, I'm gonna put you and Mr. Gotra. Mr. Amadeo, do you wish to go in the breakout room?
I actually have to go to another court, Your Honor. Mr. Noe will take it from here. Thank you, Judge.
All right, thank you. All right, so I'm going to put you guys in a breakout room, and Ms. Brenner, I think I have your people now. So, all right, so Mr. Moore, Mr. Gotra, and Mr. Noe, no, Mr. Noe. All right, I opened up the breakout room. Okay. Spalding, I think I got Mr. Spalding in my waiting room. And Mr. Murphy, I know I got Mr. Lau, and I'll be right with him. And who do I have at the jail?
Mr. Norgan?
Okay, good, thank you. All right, I just need to get Ms. Brenner out of here. Ms. Brenner, you going to see JC this weekend?
No, I actually won the lottery for it, and I was like, I'm not sure that that's up my alley. So I didn't get tickets.
All right, I have a gentleman zooming in from his car. What's your name, please?
Chris Spalding.
Okay, excellent. This is in the matter of the people of the state of Michigan versus Christopher A. Spalding, file number 2023-21286H. I have Rhonda Underwood appearing on behalf of Mr. Spalding, and I have Sarah Brunner appearing on behalf of the Attorney General's office. This is a date and time set for a pretrial. So, Ms. Underwood, how do you wish to proceed on behalf of Mr. Spalding?
Your Honor, Mr. Spalding has made a $350 payment, I understand, which should be reflected in the next couple of days. But he does have a receipt. I've talked to Ms. Brenner, and we've agreed, Your Honor, that a 60-day adjournment would be appropriate in this matter to give Mr. Spalding a chance to make a couple more payments and get a regularity established.
That's correct, Your Honor.
August 30, is that a good date?
That sounds fine, Your Honor.
All right, so I will set this for another pretrial on August 30 at 8:30 in the morning, Mr. Spalding. So write it down, because I've given you notice on the record. So we'll see you back August 30 at 8:30 in the morning, and just keep making those payments, okay?
Okay, can I ask you a question, please?
Me? Okay.
Yeah.
Maybe.
Well, last time I talked to you, we had to move one of my dates out because I didn't get the mail in time, and I'm positive you said that until that date, my custody order was to remain the same for every other weekend with my kids. I still have not had my kids.
So, Mr. Spalding, we're talking apples and oranges here. So this is a felony child support case. I don't have your custody file with me, and I can't make any determinations on your custody file. I also can't give you legal advice, so I have no idea what the answer to be on that because I don't have your file. So feel free to call your friend of the court worker to ask them for that information.
Okay.
Your Honor, just for the record, I will prepare the stipend order.
And you can sign it with my permission, Rhonda. Thank you. And Your Honor, from what I'm looking at on my end, there shouldn't have been any interference with his parenting time. So he just does need to address that with the front of the court, but there's nothing that we did on our case that would have affected his parenting time.
Okay. All right. Thank you, sir.
Thank you, Your Honor.
All right. Mr. Lau, Mr. Murphy.
Yes, Your Honor.
Okay, hold on a second. Who is? All right, Mr. Murphy, why don't we take care of Mr. Lau, and then I can give you a breakout room with Mr. Norton.
Okay, Your Honor.
All right, Mr. Lau, we're getting like a lot of wind. So it probably doesn't sound loud to you, but it sounds really loud to us.
Okay. I'll go get in the car here. Sorry about that.
It's okay. Take your time.
Okay, thanks.
So this much better. Thank you. So this is in the matter of the people of the state of Michigan versus Dennis William Lau II. We have three files, 22-20692 FH, 22-20836 FH, and 22-20837 FH. I have Matthew Murphy appearing on behalf of people, Phoebe Neer appearing on behalf of people, Matthew Murphy appearing on behalf of Mr. Lau. I do have a June 12 of 2023 letter from Darren Coast, who is my trial services coordinator, who states that since the last violation, Mr. Lau has been doing an outstanding job, test positive for Suboxone. He does have a prescription for it. He's going through medically assisted treatment, and he is in counseling at McCullough Vargas. He is making tremendous progress and appears serious about his recovery. I did have a Cobb's conference with, yesterday, was that like a year ago, but yesterday with Mr. Murphy and Ms. Meir to discuss Mr. Lau's files. So, Mr. Murphy, how are we proceeding today?
Your Honor, Mr. Lau wishes to accept the offer from the prosecution, so I'll place on the record, the plea offer from Ms. Meir was for Mr. Lau to plea in file 2220692 FH to domestic violence, to plea in file 22.
Hold on. Say the count, so, because I can't shuffle paper that fast. So count 3, domestic violence on the 692 file, right?
Yes, Your Honor.
Okay.
And on the file 836, it would be to count 7, possession with intent to deliver methamphetamine, which I believe is an added count. And then count 3, receiving and stealing stolen property and motor vehicle. And then
count
in
7 and
file,
count 3, okay, and then on file number 22-20837.
yes, there'll be a count 6, possession of methamphetamine, which I believe is an amended, and added count 6, and then count 4, resisting and opposing an officer. And the agreement, from my understanding from the cops conference, it would involve no initial incarceration beyond what he's got credit for. But that if there was a violation, the court would be looking at going above and beyond the guidelines that we've discussed.
Okay. All right, is that a correct recitation of the plea? Ms.
Hello?
Underwood, can you mute yourself, please?
Hello?
Hello.
Ms. Underwood, can you mute? Okay. All right, we get back to the felony information. So. Hold on, I'm just organizing your files. All right, so on file number 22-20836 FH, he's only pleading to count 3 and count 7. Is that correct?
On 8,
Yes,
yes.
I believe so.
All right, I think at one time we had count 1, but okay. All right, so.
I think those.
Okay. Okay. All right, I'm organized now. So, all right, so that was a correct recitation of the plea, Ms. Muir.
I believe so, Your Honor.
All right, so Mr. Lau, you want to raise your right hand for me so I can see it on the screen? All right, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record, please?
Dennis William Lau II.
Very good. Now, you can put your hand down. Mr. Lau, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 22-20692FH to plead guilty to count 3 domestic violence, which carries a maximum penalty of up to 93 days in jail and or a $500 fine?
Yes, Your Honor.
All right, and then on file number 22-20836FH, is it your intention on that file to plead guilty to count 3 stolen property, receiving and concealing a motor vehicle, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine, along with count 7, controlled substance, delivering, manufacture methamphetamine, which carries a maximum penalty of up to 20 years in prison and or a $25,000 fine? So is it your intention to plead guilty to both of those counts?
Yes, Your Honor.
All right, now, Mr. Lau, on page or on file number 22-20837FH, is it your intention to plead guilty to count 4, police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine, along with count 6, controlled substance, possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison and or a $15,000 fine?
Yes, Your Honor.
Okay, so Mr. Lau, Mr. Murphy diligently did your guidelines, which actually would call for a prison term, but there is an agreement that you will serve no further upfront jail. But do you understand, because you have prison guidelines, if you violate, you could potentially go to prison at that point?
Yes, Your Honor.
Okay, all right. Are you satisfied with your attorney and the advice that he has given you?
Yes.
Okay, other than that agreement that was placed on the record, Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Meir?
That's correct.
Mr. Murphy?
That's correct, Your Honor.
And Mr. Lau, is that correct?
Yes, Your Honor.
All right, okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. You also have the right to testify at your trial if you want to testify. So, Mr. Lau, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so we're going to start on file number 22-20837FH. So, Mr. Lau, how do you wish to plead to the charge that on or about March 15 of 2022 in the city of Morenci in the county of Lenawee that you did commit the offense, count 4, police officer assaulting, resisting, or obstructing? Guilty or not guilty?
Guilty.
All right. And Mr. Lau, how do you wish to plead to the count 6 on that file that on or about that same date of March 15th of 2022 in the city of Morenci in the county of Lenawee that you did commit the offense of possession of methamphetamine? Guilty or not guilty?
Guilty.
Okay. And then move on to the next file. File number 22-20692FH. Mr. Lau, how do you wish to plead to the charge that on or about October 19 of 2021? Ms. Meir, we need to have a talk about why they don't have cities on felony information, but do you know where this occurred?
It would have been in Morenci, Your Honor.
Yeah.
Yeah, the same address.
Okay, so all right, so on or about October 19th of 21 in Morenci in the county of Lenawee that you did commit the offense of domestic violence, guilty or not guilty?
Guilty.
All right. Do you need to meet with your client, Mr. Glazier?
I just talked to him. We need to have Jackie come down.
Okay, Ms. Meir, could someone send a message to Ms. Weiss that if she has a moment to come down to the courtroom?
And bring in amended information.
And bring in amended information.
Yes,
All
I
right.
can.
All right, so Mr. Lau, on file number 22-20836FH. Mr. Lau, how do you wish to plead to the charge that on or about January 28th of 2022 in the city of Morenci in the county of Lenawee that you did commit the offense under count 3 of stolen property, receiving and concealing a motor vehicle, guilty or not guilty?
Guilty.
All right, and then on count 7, on how do you plead to the charge that on January 28th of 22 in the city of Morenci in the county of Lenawee that you did commit the offense of controlled substance delivery, manufacture of methamphetamine, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
All right. Do you understand that if I accept the plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Meir,
No, Your Honor.
Mr. Murphy?
No, Your Honor.
Other than the plea agreement that was placed on the record, Mr. Lau, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
All right, is it your own choice to plead guilty?
Yes.
Okay, so, Mr. Lau, we're gonna start on file number 20. Let's start on file number 22-20692 FH. So, Mr. Lau, on October 19th of 2022, were you in the city of Morenci?
Yes.
All right, and were you with an individual with the initials of the MR?
Yes.
All right, and then when you were with her, did you have a rifle?
Yes.
Okay, and did you hit her, punch her, kick her, push her, pinch her, slap her? What did you do?
No.
Okay, you had a gun, right?
Yes.
And were you waving the gun around?
Yes, Your Honor.
Would you agree a reasonable person would have felt threatened or intimidated or in
Yes.
fear of an assault by you waving the gun around in a threatening manner?
Yes, Your Honor.
Okay, and were you kind of waving the gun around in a threatening manner?
She was trying to steal my dog in her vehicle, and she was backing out of the driveway, and I just waved the gun at her, so she didn't take my dog.
Okay, okay, Miss, and that's unfortunately not permissible, but Miss Meir, anything else?
What's your relationship with that individual?
She was my girlfriend. That's not no more though.
Okay. And do you agree at some point you did push her down when you were still in the trailer?
No.
When she was trying to get out of the trailer, you didn't push her down?
Nope. I have two witnesses too that were here that.
So yes or no?
No, you would agree that you were waving the gun in a threatening manner at her to stop her from taking your dog. Oh.
Miss Meir, are you satisfied that you waved a gun around and threatening an assault? Okay.
Yes, Your Honor, thank you.
Okay. Okay. That file aside. All right, let's move on to file number 22-20836 FH. Okay, so Mr. Lau, on or about January 28th of 2022 in the city of Morenci, in the county of Lenawee, did you come in to possession of a snowmobile?
Yes, Your Honor.
Okay, and where'd you get the snowmobile?
It wasn't mine. It was buddy of mine. That was living with me. It was just on my property.
Okay, and and so that snowmobile was on your property?
Yes.
And it was stolen?
Yeah, yes.
And you didn't call the police and report it or turn it over?
No, I didn't know it was stolen. It was he had it here. And
all right, so Mr. Murphy, if your client can't admit to what happened, I can't take a plea.
Your Honor, could I just have a breakout session with him, please? For just one moment.
All right, so Mr. Lau, I am going to put you in a breakout room with your attorney. So hold on.
Okay.
All right. Go ahead and join that breakout room. And the gentleman from the jail, Mr. Murphy, is your attorney, so we'll have to wait for that. I do have Mr. Crystal, Mr. Goldstein.
Your Honor, he is not here. I'm not sure why, but it is a motion hearing and I'm willing to waive his presence.
I have him. He's in Zoom.
I'm sorry?
He's he's in Zoom. I've got him. He's here.
Oh, he is? Oh, okay, because I didn't see him on Zoom. Sorry.
That's okay. Hold on. Let me grab his file. I just let him in. I don't let defendants in until I call the case. So it's a motion hearing. All right. Okay. So this is in the matter of the people of the state of Michigan versus Alan David Crystal, file number 2022-20896H. I have David I. Goldstein, P14130, appearing on behalf of the defendant. And I have Isaac Sneed, P68786, appearing on behalf of the people. Mr. Crystal has zoomed in. This is the date and time scheduled for a motion to modify bond. Mr. Goldstein, you may proceed.
Your Honor, before I do, I've turned my camera off. For some reason, the audio is very, very faint, and in order to be able to hear, I've got to hold the phone up to my ear. So that's why I turned my camera off.
Well, thank you, because I don't want to see your ear.
Okay, thank you. Judge, I'll make this very simple. It's when bond was set in this matter, there were conditions placed on the bond, particularly with regard to my client's contact with children, rather, I'm just going to say females, but children under the age of 18. Over the period of the course of this matter, that has been slightly modified to broaden a little bit. And my client certainly appreciates the fact that both the district court and this court have allowed him to remain freedom during the pendency of this action. But this matter is still going to be several months before it's resolved. My client is trying to live his life as normally as possible, and the restrictions on the bond are making it very, very difficult. Now, I'm referring specifically to where he's able to go, because where he goes in his community, it means he's going to have contact with minor children. He has children who are in school. They are involved in school activities such as sports and band and so forth. And I did read Mr. Sneed's response, and I would indicate that a lot of the response had to do with, quote unquote, the seriousness of the charges. I think those were all raised when bond was originally set in this matter and are more appropriately considered at that time. And yet the courts, both the district court and the circuit court, found it appropriate to allow Mr. Crystal to remain at large, or I'm sorry, on bond. But I think the most important thing, although Mr. Sneed sort of sloughs it off in his answer, is that he's been on bond since the beginning of this case, which I believe is more than a year. And there's been no report of any problems with him while he's been on bond. Nobody has reported that he's had, for example, there's been no contact with the victim or the victim's family that's been reported. There's no indications that his behavior while he's on bond has been at all questionable. And we're simply asking the court to say, okay, you're free on bond. As long as you're in the presence of your wife, you can go anywhere you want and do anything you want, which is what most bonds are.
So his bond currently is he can have contact with people outside of his immediate family as long as he is in the presence of his wife.
No, that's what we're asking for, Your Honor.
Oh.
Well, I guess Mr. Crystal frankly would like it with no condition at all, that his wife need not be present. So we're going to put that on the table also. But right now he has to get permission, for example, if he wants to go to a band concert, he wants to go to an athletic event at the school, because there are other kids around. The restriction is he can have contact with members of his own family, whether or not his wife is present. But beyond that, I believe the condition is that his wife must be present.
All right.
And I know I'm sorry.
Oh, go ahead, Mr. Goldstein.
No, I'm just going to say in conclusion, Your Honor, Mr. Crystal would like that restriction taken off completely, or as an alternative that he be allowed to go anytime, anywhere, as long as his wife is present.
All right. So, Mr. Sneed, I want to apologize first. I do not have a response in my file. It's probably not made its way across. So if you could summarize your response for me, please.
I will, Your Honor. Point out that the defendant's motion doesn't cite any legal authority in support of the motion.
in my motion under MCL 765.6, the bond factors have to deal with the seriousness of the charges. The defendant's believed to have been under the influence of alcohol when he accosted the minor in his kitchen, stuck his hand down her pajama pants and inserted his finger into her butt, then prescribed medication due to the psychological trauma. She had to move to a new school for the 2022-2023 school year. Her parents have reported behavioral issues, bad grades, psychological symptoms which did not exist prior to being victimized by the defendant. In addition, the defendant's modus operandi involved grooming behavior toward the minor victim, which preceded the incident, leading to the criminal charges. He would frequently hug and touch the victim, give massages under her shirt, starting at the age of approximately 10 years old. By the ages of 13 or 14, he would take pictures of the victim and tell her she's pretty. He would ask why she was dating a certain boy. Despite the lack of significant criminal history, this behavior involves a minor child outside of the defendant's immediate family, and that's what the bond condition is designed to protect at this point. The court has been lenient due to the delays that have been requested by this defendant in adjourning the trial. In addition, under the MCR 6.106 F1 bond factors, there is pertinent information for the court to consider. Again, based on the foregoing behaviors of serious concern over the defendant's mental condition, specifically the grooming behavior, photographing, as well as the physical touching of the minor victim. The minor victim and her family have suffered in this case. There's a probability of conviction. This case was bound over after the exam was held, and the potential for a prison sentence. The people have no information on community members who could vouch for the defendant. And lastly, the people submit the defendant poses a danger to minor females who are not his family members based upon the prior actions. So based upon that, we're asking the defendant's motion be denied. Thank you.
Anything else, Mr. Goldstein?
Yes, Your Honor. First of all, I'm not going to challenge Mr. Sneed on his statements as to the serious effect that that my client's actions allegedly had on the victim and her family. That's probably more appropriate for the court to consider at the time of sentencing if the defendant is convicted. But Mr. Sneed did make one statement of fact, which is not true. In the initial statement the victim made to the police, there was no mention. This was originally charged as a CSC second, because in her initial statement to the police, she talked about, as Mr. Sneed described it, placing his hand on her buttocks. In her second statement to the police, which came after this matter was charged, she told the police, I believe it was the police, it may have been the forensic interview, that as his hand was coming out of her pants, one of his fingers went within her buttocks. So there was no allegation that he ever inserted his finger into her buttocks. That's number one. Number two, there is an old, the old saw, Your Honor, that actions speak louder than words. My client has been on bond for an extended period of time. There is no claim that at any point in time he did anything to violate that bond with regard to alcohol, with regard to drugs, with regard to contact or communication with other minors. So I think my client has proven that he is not a danger, that he is not a risk. And again, not to minimize the part of Mr. Sneed's presentation regarding the effect that this case has had on other people, that's more appropriate for the court to consider at the time of sentencing.
Okay. All right. Well, I'm going to deny the motion to modify bond. Obviously, Mr. Goldstein, I understand your court that he has not yet been convicted, but the nature of the offense for the reasons as stated by Mr. Sneed under statute, I think his bond is lenient enough as it is. There are no school functions during the summer, and he's set for trial the second week of September. So I think that's pretty close and it'll be by school time. So depending on what happens at trial, you may be able to attend school functions. So I am going to deny your request, Mr. Goldstein. Thank you.
All right, thank you, Your Honor. I'll present an order.
All right, thank you. All right, Mr. Crystal, you're all set. All right, so, Mr. Murphy and Mr. Lau. Are we ready to resume?
Thank you, Your Honor, for that breakout. I believe Mr. Lau wishes to proceed with the plea.
All right, so Mr. Lau, back to file number 22-20836FH. We were on count 3, stolen property receiving and concealing. So Mr. Lau, on January 28th of 2022, were you in the city of Morenci in the county of Lenawee?
Yes,
Now, at that time, a snowmobile was brought to your property by another individual. Is that correct?
yes, Your Honor.
Okay, and the statute requires that you knew or should have known or had a reason to believe that the snowmobile was stolen. Would you agree that you should have known that that snowmobile was stolen?
Yes, Your Honor.
All right, and you didn't contact the police to come get it or report that you had a stolen vehicle on your property?
No, I did not.
Ms. Meir?
I would be satisfied with that factual basis.
Okay, so then we're gonna go on to count 7, Mr. Lau. On that same date in the city of Morenci and the county of Lenawee, did you also have in your possession methamphetamine?
Yes, yes, Your Honor.
All right, did you know it was methamphetamine?
Yes,
And was it enough that it was your intention at some point to, or no, it was just a possession. So, so you knew it was methamphetamine. Is it methadone? Or no, it was methamphetamine. Did you have any legal right to have methamphetamine?
no,
All right, and was it your intention, you didn't do it, but you possessed it with intent at some point to deliver it, to give it to somebody or sell it?
yes, Your Honor.
All right, Ms. Meir?
Would you agree it was packaged in such a way for delivery?
Yes,
Okay, I'm satisfied with the factual basis.
All right, so let's move on to file number 22-20837FH. Mr. Lau, on March 15th of 2022, were you in the city of Morenci in the county of Lenawee?
yes,
Okay, and at that time, you came into contact with a Michigan State Police trooper, is that correct?
yes, Your Honor.
All right, and so we're going to specifically reference, there were 2 of them, but we're going to specifically reference Lieutenant Moore. So was he in full uniform?
No, Your Honor.
I'm sorry?
No, he wasn't. He was just in street clothes.
Okay, and did you know he was a police officer though at that point?
Yeah,
Okay, and did he try to arrest you or take you into custody?
yes, yes, Your Honor.
Okay, so tell me, you did something to oppose arrest. So you either assaulted him, resisted him, opposed him, battered, wounded, whatever it might be. You could have ran away. You could have pulled your hands away from the handcuffs. Tell me what you did to resist arrest.
I pulled away from him. My hands away from him.
Okay, and you knew he was a police officer and he was trying to lawfully arrest you at that point.
Yes,
Ms. Meir?
Satisfied, Your Honor.
All right. Now, at that same time, did you again have in your possession methamphetamine?
yes,
And you knew it was methamphetamine?
yes,
And you had no legal right to possess methamphetamine, is that correct?
no, Your Honor.
Are you satisfied with that one, Ms. Meir?
Yes, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Meir?
It has.
And did I say something wrong?
No, I got a text at the same time. I'm sorry.
Oh, okay. All right, and Mr. Murphy?
Yes, Your Honor.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case, other than what was placed on the record with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Mr. Murphy and Ms. Meir, is July 27 a good date for sentencing?
Yes, Your Honor, it is for myself.
I know you're gonna be gone, but I don't know that you need to be here on this one,
Yeah,
right?
that's what I was gonna say. Yep.
Okay, all right, so I'm going to set this matter for sentencing on July 27 at 8:15 in the morning. So, Mr. Lau, because there's an agreement that you're not to do any more upfront jail, you can appear in person for sentencing, or I can allow you to Zoom in.
If I could Zoom, I'd appreciate it.
Okay, so, Mr. Lau, in a minute here, I'm gonna put you in a breakout room with Tom Moore from the Michigan Department of Corrections and give you an opportunity to speak with them. He's gonna give you instructions. You're gonna have to meet with them 1 or 2 times. Make sure you attend those appointments. And when you meet with them, be truthful about your background. Be truthful with them about the events that occurred. Mr. Lau, because you've been being very diligent and trying to involve yourself in recovery and been doing so well, you've been afforded a great opportunity. We obviously would prefer giving people help to overcome addiction, because locking them up usually doesn't help at all. So, Mr. Lau, I really hope that you work really hard at this, okay?
Yeah, I will, Your
All
Honor.
right, and we'll see you back for sentencing on July 27th at 8:15 in the morning. So, Mr. Moore, I'm going to put you and Mr. Lau into a breakout room. There you go. So go ahead and join that breakout room. Mr. Murphy, I have your client, Mr.
Yes, Your Honor. Could
Mr.
I
Norden.
speak to the breakout briefly? Mr. Norden.
All right, so Mr. Norden, I'm going to put you and Mr. Murphy into a breakout room. Go ahead and have a chat with them, all right?
Yeah, thank you.
So do we need to have a bench conference on this, or?
I don't think so.
No?
I do have amended information. I know she emailed it, but I also brought you a hard copy if you'd like it.
Yep. All right, so Mr. Dietos, you want to go up to the podium?
Your Honor, could I ask, this might take some time. Could my client do it from the chair?
No. You can sit, he can stand.
All right.
You don't have to stand.
Okay, that's fine.
All right, no, I just need him at the podium, not you. All right, so Mr. Dietos, okay, so this is in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Dietos, and I have Jacqueline Weiss appearing on behalf of people. It's because my court reporter faces you all this way to do a record, so it's easier for her if you're all there. All right, so Mr. Glazier, this is a date and time set for a pretrial. I have received an amended felony information. Count 1, child abuse first degree. Count 2, homicide open murder. And count 3, homicide manslaughter. So, Mr. Glazier, how do you wish to proceed today?
Your Honor, we intend on entering a plea to count 1, the child abuse first degree, and to count 3, the manslaughter, with the understanding that count 2 would be dismissed at the time of sentence.
Right. Is that a correct recitation of the plea, Ms. Weiss?
That's correct, Your Honor.
All right, so Mr. Dietos, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I am.
All right, can you state your full name for the record?
Christopher Nicholas Dietos.
All right, so Mr. Dietos, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, child abuse first degree, which carries a maximum penalty of life or any term of years, as well as count 3, homicide manslaughter, which carries a maximum penalty of up to 15 years in prison and or a $7,500 fine. So is it your intention to plead guilty to both of those counts?
Yes, ma'am.
Okay. Are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, ma'am.
Okay. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
That's correct.
And Ms. Weiss?
That's correct.
And
Oh,
Mr. D?
Your Honor, it's not correct. Actually, and I forgot to put this on, the prosecutor and I have had a discussion, and there would be a killable plea, Your Honor, that the sentence would be within the guidelines. And the prosecutor and I agree that the guidelines work out to be 11.8 years to 18.75. Is that right?
Yeah, I got 135 months to 225 months.
Yeah. And that the maximum would be a term of years to be determined by the court, not a life sentence on it.
All right, so you guys are stipulating that the guidelines are 135 to 225, that he will not be given a sentence of life, that he will be sentenced to a term of years. And
that's it.
That's it. There's not a kilogram that he would be sentenced within the guidelines, no?
Oh, yeah,
The bottom-
it is within the guidelines.
Within the bottom end would be within the guidelines, and then the top end, whatever the court determines.
Okay, so the sentence would be, okay. So anywhere from 135 months to a maximum of 225.
No.
Right.
No.
On the bottom end, yes. So it's, yes, but you could do whatever on the top.
Top end, you can do it, whatever, just it wouldn't be life.
I need a bigger post-it. Here's the little one, bigger one. Okay, so. So the plea would be the low end of the guidelines to whatever.
Term of years.
Okay, so the 135.
No, it's not. It's not.
It's
to
not the low end.
of the
It's
guidelines.
anywhere which
Okay.
135 to
Within the
225 to whatever.
Okay. All right, so, Mr. Dietos, do you understand that's part of the agreement too?
Yes.
Anything else, Mr. Glazier or Ms. Weiss?
No, you're right.
No, you're right.
So other than that, though, Mr. Dietos, neither the prosecutor, the defendant, nor anyone on your behalf has discussed any other possible sentence with court. Is that correct? So treatment, whatever. Okay. Would you agree with that, Ms. Weiss and Mr. Glazier?
Yes, sir.
Yes, Your Honor.
Okay, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would have been otherwise appealable had you been convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the sentence and conviction, from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
That's done.
So if you had been convicted at trial, you would have had an automatic right to appeal. But because you're entering a plea, you don't have an automatic right to appeal. You would have to file paperwork for leave to appeal, and they would have to decide whether they would grant that or not. Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? All right, so Mr. Dietos, how do you wish to plead to the charge that on or about September 1 of 2021 in the village of Blissfield in the county of Lenawee, that you did commit the offense of child abuse first degree, guilty or not guilty?
Guilty.
And how do you wish to plead to the charge that on September 1 of 2021 in the village of Blissfield in the county of Lenawee, that you did commit the offense of homicide manslaughter, guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges other than what was placed on the record? Is the prosecutor or defense counsel aware of any other promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
And Ms. Weiss?
No, Your Honor.
Has your attorney, I mean, we put your basic sentence on the record, but other than that, has your attorney promised you any particular sentence or estimate what your sentence will be other than the agreement? Like treatment in prison or fines and costs or anything?
No.
All right, would you agree with that, Mr. Glazier?
I would, Your Honor.
All right, and is it your own choice to plead guilty to these charges? All right, so, Mr. Dietos, on September 1
Your
of,
Honor, can I ask if there's?
You wanna-
I
you
want
can
to
do
put
it.
on the record, then I could ask the factual basis after that.
that's fine, Ms. Weiss, any objection to that?
No, Your Honor.
All right,
Your Honor, for various reasons, I wanted to engage Mr. Dietos with some question and answer before I go to the factual basis. Mr. Dietos, you're aware that we had a criminal responsibility and a criminal competency exam done by the state of Michigan, is that correct?
Yes.
And you participated in that,
Yes.
and that took place for several hours. Was it one day or 2 days?
One day, I think.
Okay, and you are aware that you were found to be criminally responsible by the state of Michigan psych unit, as well as competent. You understand that that was their basis, and you've seen those reports. Is that true?
I think so.
Right. You don't think that was what their report said?
Oh, yes, I do. I'm sorry.
You and I met back just last weekend, June the 6th. And we spent an hour or so going over various documents and forms and jury instructions, et cetera. Is that correct? You gotta say yes or no, because you're being recorded.
Yes.
All right. One of my concerns, and actually I knew this before the reports were done, was your father indicated you had a very low IQ. Is that true?
Yes.
And in fact, some of the documents that were presented to the state of Michigan shows that your IQ was actually, when you were 7 years old, the test reflected it was 51. 51, was that correct?
Correct.
And you understand that's very low.
Yes.
All right. Now, your father, who passed away
Yes.
while this is proceeding, advised me that you are quite capable of understanding things and communicating and expressing yourself. Is that true?
Yes.
I would also place on the record that I find him to be very capable of communication and understanding what I've been trying to tell him. I think.
Okay.
When I went down to the jail last week, I presented to you a plea bargain that was offered by the prosecutor. Is that correct?
Yes.
And in fact, it's the plea bargain that we put on the record here today. Is that true?
Yes.
And you understand that, and I didn't write down the exact months, but your minimum sentence is going to be determined by the judge. You understand that?
Yes.
And that will be within the guidelines.
Yes.
You understand that? And the prosecutor and I have them at, what is it again, month less?
135 to 225 months.
That your minimum sentence will be between those months. Do you understand that?
Yes.
That is roughly 11.8 years to 18.75, I believe. You understand that?
Yes.
That means when you come back for sentencing, the judge is going to set a minimum sentence that is somewhere between those. You understand that?
Yes.
So the earliest you would be, that's when you're eligible for parole. That's when you have served your minimum sentence. You understand that?
Yes.
So at the very earliest that you would be eligible for parole is going to be approximately 11.8 years. You understand that? Minus whatever time
Is
you
that
served.
like 12 or so? Or-
Almost 12. But the judge could go up as high as almost 19, 18.75 years. You understand that?
Yes.
That's just your minimum sentence. That's where you become eligible for parole. You understand that?
Yes.
The maximum sentence on this could be up to life, but we have agreed it'll be a term of years. You understand that?
Yes.
What that means is that if they don't grant you parole the first time, second time, third time, the fourth time, there's going to be a maximum that you could serve if you don't make parole. You understand that?
Okay.
Okay, you're gonna have to serve at least a minimum of, let's say the judge picked 12 years. That means you're gonna have to serve at least 12 years, at which time you'll become eligible for parole. You understand that?
Yes.
You'd apply for parole, you'd have a parole hearing. If you were granted parole, you would get out on parole following the hearing. You understand that?
Yes.
Now, they could deny your parole, which is called flopping. You've heard them say flop. That's basically being flopped, and then you become eligible for parole again. And it's not a homicide, so I'm not sure what it is, but it's at least every 5 years. It might be quicker than that. And so then you'd apply again in 5 years, get parole, you're out. If you don't, keep going. If it went all the way up to the maximum, they'd have to release you. We don't know what the maximum is, because the judge is going to set that when you get sentenced. You understand that?
Yes.
I asked her and we agreed that it would not be a life offense. My sole reasoning behind that is I know the parole board on second degree murders where it is a life offense are less likely to parole you. And so I didn't want anything that said life offense is the maximum. You understand that?
Yes.
So to summarize, you're going to get a minimum sentence between almost 12 or to a little less than 19. That's going to be your minimum. And your maximum is going to be a term of years that the judge is going to set. Okay?
Yes.
You understand that?
Yes.
Now, when I talked to you at the jail, and I also talked to you here today, I advised you that I could get an independent evaluation done as to your competency and your criminal responsibility. Is that true?
Yes.
And you understand that would not be by somebody from the state of Michigan, that would be by somebody that I choose that I would hire.
Correct.
And they would reevaluate your competency to stand trial as well as your criminal responsibility to stand. Do you understand that?
Yes.
Regardless of what those findings are, you would have a right to a trial. Do you understand that?
Yes.
And if my independent evaluator said, hey, you weren't criminally responsible, you weren't competent, that would be an issue or criminally responsible, excuse me, that would be an issue raised at trial. Do you understand that?
What does that mean? Like,
that means if we went to trial, you could present, it's sometimes referred to as an insanity defense. But that because of a mental illness, you don't appreciate the wrongfulness of your acts, basically. And it'd be a fight between the state of Michigan and our expert if he deemed you to be not responsible as to whether you're not guilty by reason of insanity. Do you understand that?
yes.
But likewise, the jury could still find you responsible and find you guilty of child abuse first and open murder. You understand that? First degree murder.
Yes.
And you're choosing not to have that evaluation. In fact, I told you that's what we were going to do, and you told me, I think last week and again today, that you don't want to have those evaluations done. You want to proceed with the plea record. Is that correct?
Yes.
All right. So just so you understand, and I want to make sure you understand this, and it's kind of tricky. You're charged with open murder, but there's a charge that is referred to as felony murder. I've explained that to you.
Yes.
Okay, basically what felony murder says is that if you commit a murder, if someone dies by your acts during another crime, and the crimes are listed within the statute, that you are guilty of first degree murder, could be found guilty of first degree murder. You understand that?
Yes.
And I've explained to you that one of those crimes is child abuse in the first degree. You understand that?
Yes.
So if you went to trial and a jury found you guilty of child abuse in the first degree, they could find you guilty of felony murder, which is first degree murder. You understand that?
Yes.
And first degree murder carries life without parole. I've explained that to you.
Yes.
So that's the risk for you, is if they find you guilty, if a jury found you guilty of child abuse in the first degree, they could find you guilty of felony murder and you could face life without parole. You understand that?
Yes.
That's not to say they would, but that's what the risk is for you. You understand that?
Yes.
All right. Now I've explained to you, child abuse in the first degree requires a jury to, you don't have to, they don't have to show intent, but they do have, the prosecutor would have to show that you knowingly or intentionally, which would be intent, but knowingly cause physical harm to a child, serious physical harm to a child. You understand that?
Yes.
All right. And you don't wish to take that risk and want to take the plea bargain at this time.
Yes.
Do you have any questions or of either the court itself at this time that need to be answered?
Not this time.
You understand everything that we've gone over both at the jail and tried to put on the record here today.
Yes.
And you still want to proceed with this plea, is that correct?
Yes.
All right. I'm going to ask you some questions about on the amended information. You understand, I want to show it to you, that this homicide is going to open murder, which could be first degree murder, is going to be dismissed at the time of sentencing. All right, what you're pleading to is count 1, child abuse first degree, and count 3, homicide manslaughter. You understand that?
Yes.
All right. We'll go over a couple things. On September 1st of 2021, were you watching or taking care of your son?
Yes.
And that is Weston Dietos?
Yes.
And at that time, he was born on June 23rd of 2022, is that correct?
Yes.
So on that date.
Well, hold on a
Yeah,
second.
he couldn't have been born after the date of the offense.
The date of offense is September 1 of 21.
Did I say June 23rd?
You said 2020.
I think it was this
June 23rd.
last year, the 23rd.
June 23rd, 2022 is what I meant to say.
Right, you keep saying 22. It's not, he couldn't have been 2022 because he had to have been born before the offense date, John.
Oh, okay, I didn't notice the offense date. Well, that's his date of birth.
What day was your child born?
Maybe your offense date's from.
June
Yeah.
23rd, last year.
2022, so
The-
the on or about, can I amend it to September 1st, 2022, so the information is incorrect?
Are you going to amend that today?
Yes,
Yeah, we have no objection.
sorry, John.
So it's September 1 of 22.
Yes.
All right, we'll go back to Mr. Dietos, your son, Weston Dietos was born on
June 23rd.
June 23rd of 2022, is that right?
Yes.
So on the date of September 8th, or excuse me, September 1st, we got that date right, because the date of death says September 8th.
September 8th.
That date wrong also?
Yep, September 8th.
So we need to amend that to September 8th of 2022. Aaron. What's that?
I guess so. What are we doing?
Changing the date to honor about September 8th instead of September 1st.
So September 8 of 22?
Yes. Mr. Diethos, on September 8th of 2022, your son would have been about 2 months and a couple of weeks old. Is that correct?
Correct.
And you were caring for him at that time?
Yes.
And the mother was gone and you were the sole
caregiver.
providing the
She was at some kind of class that she had to take out in Adrian by the college.
All right. And the child became upset and was.
I had a mental breakdown.
I understand that. You understand that you're, by pleading, you're giving up any type of defense, saying that a mental breakdown caused this, it caused you to have injure your child. You understand that? The child was being fussy or acting out, or it got you frazzled. Is that a fair statement?
What's frazzled?
Upset or
Yes.
nervous?
Yes.
Okay. And as a result of that, you grabbed your child and shook the child rather violently. Is that correct?
Yes.
Now, you knew that shaking the child in that manner could cause serious physical injury. Is that true? And as a result of that, your child eventually did die from being shaken. Is that correct? Yes. It was. And this all occurred in Lenawee County here in the state of Michigan. Is that true?
Yes.
You're absolutely sure this is the way you want to handle this thing today?
Yes.
I don't have any other questions.
Any other questions, Ms. Weiss?
At the time that you shook the child, you intended to shake the child to get it to stop crying?
I didn't want to. Yes. I didn't mean for him to pass away though.
And nothing further, young.
Ms. Weiss, could you also, do the amendment, correct the first name of the child in count 3?
Yes, and I looked at the report and it looks like the death certificate listed date of death is September 8th, but it's all September 1st, 2022.
So the event occurred, but the death certificate was dated September 8th.
The death certificate lists the date of death as, so that may be in there.
That's from the coroner's office, yes, but the actual date is September 1st, 2022. So I'm going to leave the September 1st date on it.
That's fine. I was just asking questions based
on. No.
Yeah.
date of
I
death.
Okay, Ms. Weiss, is there anything else you wanted to add to that or ask Mr. Diethos?
No, Your Honor.
Has court complied with MCR 6.302 B, C, and D?
Yes, Your Honor.
Yes, Your Honor.
All right, and I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Mr. Glazier, I appreciate you going through all of that to make sure Mr. Dieto comprehends what he was entering into in the plea. So there is a Killebrew agreement to the sentencing range in a term of years. But other than that, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew. I'm going to refer this matter to the probation department for a pre-sentence investigation. Are you both available July 27th at 8:15?
I believe so, Your Honor.
Yes.
All right. So I'm going to set sentencing for July 27 at 8:15 in the morning. Mr. Glazier, would you like your client to appear in person?
Yes, I would, Your Honor. Did you say
8:15? I do 8:15. So, Mr. Dietos, I will set this matter for sentencing on July 27 at 8:15 in the morning. Now, someone from the Michigan Department of Corrections, a probation officer, is going to come speak with you over at the jail. when you meet with him, be truthful about your background, be truthful about the events that occurred.
That led up to what happened.
Just
Whatever.
talk about your background, be truthful. They'll ask you a bunch of questions. So be honest when you talk to them. They'll ask you about what occurred, be honest about what occurred. They'll prepare a report. We'll get a copy of that report to Mr. Glazier. Mr. Glazier will meet with you beforehand and review that with you. And then you'll come in front of the court that day for sentencing in person, okay? Mr. Glazier, any other?
Your Honor, the only thing I don't know if the court would want the probation, or at least the court, I'm gonna ask you to consider is maybe some mental records and evaluations. I can provide those.
You can provide those to Ms. Weiss for his mental
I
health
think she has
background.
probably seen those, but I will.
I mean, the probation department will always seek those medical records, so, and that information for the PSI, so you can provide that to the Michigan Department of Corrections if you would like, Mr. Commissioner.
All right.
All right, is there anything else we need to address on the record today with Mr. Dietos?
No, thank you.
No, Your Honor, thank you.
Okay, so Mr. Dietos, we will see you back on July 27 at 8:15 in person. Thank you.
Here's what you want. This is what
Yeah, so.
right here, I got it right now for you.
Somebody have a jail room.
That's what the guidelines come out to. For the minimum, which is when you're eligible.
All right, from the jail, could
Okay.
you,
Those ones.
there you go. All right, Mr. Norton, Mr.
Okay.
Murphy.
I'll
So
see
we
that.
are back on the record in the matter of the people of the state of Michigan versus Daniel Philip Norton, file number 2023-21382. Mr. Murphy, you had asked for a breakout room with Mr. Norton, and then I have, looks like Phoebe Muir appearing on behalf of the people. So, Mr. Murphy, how do you wish to proceed today on behalf of Mr. Norton?
Your Honor, today is the day and time for the arraignment on Mr. Norton. At this time, we will waive a reading of the information. I acknowledge receipt of said information we received, it looks like, maybe 2 days ago or a day ago. Again, we waive any faults from that. Again, we received that in the witness list and the discovery request from the prosecution. At this time, Mr. Norton wishes to remain mute, have a not guilty plea entered for him, and would ask for a pretrial to be set. We're just asking the court to schedule it as soon as the court can find any schedule to do so.
So it looks like my next available is July 26th at 8:15 in the morning. So July 26th at 8:15, or I'm sorry, 8:30 in the morning. Our staff will prepare the notice of hearing because it's an arraignment. Mr. Murphy, in the event an agreement's been struck and your client wishes to enter a plea, please just let us know and we'll get them in right away.
Yes, Your Honor, I'll contact the court if we have something worked out before that date.
Okay, so Mr. Norton, I will see you back on July 26th at 8:30 in the morning, all right?
Thank you. Thank you, Your Honor.
Thank
Thank you,
you.
Mr. Norton. You have a good day.
Yep. So.
Go back. Back.
All right, and at the jail, I'll just take who's ever next, please.
Your Honor, do we have Brianna Spiegel?
She's in jail, so I don't know who the jail's gonna bring me next.
Okay.
I have Brianna Spiegel, and actually, she's the only one I have left, so she should be the next one, so she's the only one I have left in jail. So let's see why I have all these files.
Judge, I think you have Reed as well. Rio Reed.
Yep, I have Reed. So I have Rio Reed in jail. All right, Perez Martinez is, he's not till 1:30, Perez and Shelby's.
Yeah, but Pascal.
He's been adjourned. Yeah. So, Perez Martinez is. It's been adjourned. I don't know, Becky, if you ever need any of these files, no, or I'll bring them back. Hold on. Legal. All right, we're just waiting for the jail. I don't need you walking out every time.
Gives me a chance to move.
Huh?
Gives me a chance. to move.
Okay, I just don't want you to feel like you have to pop
No,
up.
no.
Okay, so let me take these files back to Ms. Adams.
Judge, do you know if you did Sneed yet?
Who Sneed? Yeah, Jeremy Sneed, we did.
Oh, okay. I missed that one.
We set that for pretrial on August 2nd at 8:30, both of them.
Okay, thank you.
Thanks.
Yeah, and guys, move people out of talk all time, right? That bullshit on. Yeah. So I realized it. Well, I'm gonna go take a shot when I can.
So
No jail though.
I think they were very, like, 9 or I think. Probably didn't. I didn't go to the court. I did. It's a equal time. Who told you that? I'm pretty sure that didn't happen. I feel pretty.
Hey, we're willing to do Marlon. You don't have all day to pull out, do you? Yeah. All right.
When's my clothing change? Oh, that one's long. Oh, yeah, someone's report gonna come out? I think so.
Hello, jail. Oh, great.
There we go. I have a jail window, so if someone can turn on audio and video, please. I lost, oh no, I have Rhonda Underwood. Oh, we got another jail window. Miss Underwood, are you still with us?
I apologize, Your Honor.
No, it's okay. I just wanted to let you know, I've got 2 jail windows logged on. They haven't connected yet, but they will be. And I believe you have.
I'm Ms. Spiegel, Your Honor.
All right, let me see. I have Sam Malaro. He's probably down the hall on Real Read. So can you text him and let him know? We'll probably be taking his soon too. All right, Ms. Spiegel, can you hear me?
Yeah, I can hear you.
All right, this is in the matter of the people of the state of Michigan versus Brianna Lynn Spiegel, file number 22-20816FH. This is a date and time scheduled for a probation of violation trial. The allegations against Ms. Spiegel are that she violated the terms here per probation, and that she was ordered to report as often as required, and she was released on April 27th of 2023 and ordered to report to Salvation Harbor Light, and she did not appear. So, Ms. Underwood, how do you wish to proceed on the violation of probation today?
Well, Your Honor, I know Ms. Teskey is in training, but Ms. Spiegel pled downstairs, Your Honor, to a attempted resisting and obstructing that I believe her sentencing is on the 17th of July scheduled. Ms. Spiegel, I believe, is prepared to resolve this technical violation, but I don't know if the probation department would prefer that she be sentenced first downstairs. I said to Ms. Spiegel that I would be willing to see if they can move up her sentencing downstairs, Your Honor.
So potentially she can have another violation.
That's potentially.
All right, Mr. Moore, do you know if, well, Ms. Teskey's out for training, right?
Correct. So, I mean,
So why don't we do this? Why don't we set this over to June 21?
Perfect, Your Honor. That's what I was going to suggest.
All right. So Ms. Spiegel, I'm going to set this over to June 21 at 8:30. And we'll see what's going to happen with Ms. Teskey regarding your new charge, okay?
Okay, thank you.
All right, thank you, Ms. Spiegel. Ms. Underwood, I do have Rio Reed. Are you able to find out from Mr. Malaro what he wanted to do with Mr. Reed today? And
Okay, just if you'll give me just a second. He's right next to that.
all right, hold on, Mr. Reed. We'll be right with you, all right?
Yes, ma'am. Hey, it was very, yeah. Going further at home, you plan to have to get paid for it. That's what they are. Yeah.
We're just waiting for your attorney, Mr. Reed.
All right. I ain't done yet, so.
Are you done?
No, not yet. Hey, sorry. Get back there and go ahead, man. I'm trying to get in the kitchen, man.
We grabbing or?
Yeah, I been put it in.
Okay.
All right, I got Mr. Malaro. So. Thank you, Ms. Underwood. I have Mr. Malaro now. All right, Mr. Malaro, this is in the matter of the people of the state of Michigan versus Rio Reed, file number 23-21349FH. I have Salvatore Malaro appearing on behalf of Mr. Reed and Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Mr. Malaro, how would you like to proceed?
Just gonna have a breakout with Mr. Reed real quick.
Sure. So, Mr. Reed, I'm going to open a breakout room
Okay.
and sign Mr. Malaro and you. Join that breakout room, so you can use the mouse and click on join.
Okay.
Thank you. All right, let me close that breakout room. All right, Mr. Milaro, have you had a chance to speak with Mr. Reed?
I have, Your Honor.
And how would you like to proceed on behalf of Mr. Reed?
So Judge, on behalf of Mr. Reed, there's been a plea offer that I need to go over with Mr. Reed in depth. I think once I do that and talk to the prosecutor, we should probably get a resolution. So I'd ask the court if it could grant us a adjournment for about 3 weeks.
My next available. All right, Mr. Reed, tell him you're in court and stop bothering you for a moment.
Yes, ma'am.
Okay, so my next available is July 26th at 8:30. But Mr. Milaro, that's just the next available one. If you talk to Mr. Reed and he decides he wants to take advantage of the plea bargain, if you call Miss Adams, I'll get him in right away.
Okay, Judge. Yeah, so I had a trial next week that got adjourned, so I'll go talk to him next week for sure.
Okay, so Mr. Reed, understand, I'm setting it for July 26th at 8:30. If you guys work out a plea bargain and you want to take it, Mr. Millar will get you in right away. All right?
Okay.
All right, thank you. And that concludes our morning docket.
Judge, I'll
Thank
have
you.
our office